Welcome back to our course on conflict of interest for professionals. In our previous module, we introduced the concept of disclosure or registration of conflicts of interest. In this module, we will talk in more detail about this very important topic. So what is disclosure? Basically, it is telling everyone in advance of any private interests you may have on an issue that are, or may be seen to be, a conflict of interest. As you are disclosing things here, what implicit assumption is being made? Well, we are assuming that you personally have considered the issue and that you believe you can carry on and be impartial despite the conflict. So what do you disclose? You should disclose any facts or circumstances, that is, interests, that exist that may, in the eyes of the parties, give rise to doubts as to your impartiality or independence. And you should disclose these facts or circumstances before you start, or for circumstances that arise during a project, as soon as they come to light. Note that the word may in our first paragraph there. Remember, perception counts. There's also a reverse disclosure obligation. In this case, imagine one of the parties knows of a conflict you have, of which you are unaware. They must let you know. A simple example is that their daughter is dating your son without your knowledge. If that fact came to light, some may perceive that you gave favorable treatment to the parents as an indirect benefit to your son. It is important to state that disclosing an interest does not imply that you have a significant conflict of interest. Equally, a failure to disclose does not imply a conflict of interest. That is, there is no guilt arising from simple disclosure. Disclosure simply lets the other parties know of your interest. It is then up to them to decide whether they are comfortable with you continuing on the project. If anyone has concerns, they should apply the reasonable person test to decide whether the conflict is significant. We've already seen that conflict of interest is not black and white. There are considerable gray areas. Some of these gray areas arise when considering whether to disclose something or not. While there are no hard and fast rules, one general suggestion is that if you are in doubt as to whether to disclose, you should default for disclosure. A tricky point. What if your company wants you to work on negotiations with another firm, but from personal conversations that you have promised to keep secret, you know intimate details of the other firm? In such cases, you should withdraw from the assignment, disclosing the existence of a private interest, but not necessarily giving details as to its nature. We've already discussed two types of interests: pecuniary or financial, and non-pecuniary or personal. Talk about financial interests. What types of interests should be disclosed? What criteria should you use? One general point is that whatever the criteria are, they should be clear. We've already seen this table from the International Agency for Research on Cancer. As before, while you may disagree with the numbers, it is clear as to what should be disclosed. Taking a similar but less quantitative approach, here are the Justice Canada rules. Reportable assets include publicly traded securities, when these securities are not through mutual funds, interest in companies or family businesses, real property that is not for private use, any assets you have in trust, and loans granted to people other than your immediate family. And remember, disclosing that you own shares in some company does not immediately place you in conflict. It merely allows the other parties to use that information to evaluate their confidence in you. Now, unlike the International Agency for Research on Cancer, Justice Canada rules also spell out things you should not need to disclose. On that list of non-reportable assets, we have such things as residences, works of art, antiques, collectibles, cars, cash deposits, and any loan from a financial institution that's on the terms that anyone could get. So once again, the participant guide has the full list of reportable and non-reportable assets, according to Justice Canada. Notice that the last list were all financial interests. What about personal interests? What personal interests do you think should be disclosed? Well, one major category is family, especially your immediate family, spouse, children, parents. What if your children have grown up and moved away? They're no longer dependent on you. Do you still need to disclose them? And there are more thorny issues. How about adopted children or long-term foster children? How about your dependent cousin who lives with you? And how about an ex-spouse? These and many more are all issues that should be set out beforehand when thinking about developing a conflict of interest policy. And how about your friends? Should you disclose information about them? Even more interestingly, do you need to tell the other parties that you hate someone involved in the project? Do you need to disclose your enemies? And what about business colleagues, organizations you belong to, the church you attend? How much of these personal interests need to be disclosed? Looking to another organization, the Canada Revenue Agency includes family, friends, family members, acquaintances, business associates, current and former colleagues, or current and former superiors as people to disclose and potential personal interests. The problem is they never define these terms. How good a friend? How close a business associate? Some say the scope of personal interest is too broad to require their disclosure of personal interest through lists. As one researcher said, it is difficult to envisage in advance and provide for every particular type of improper conduct that the human mind is capable of devising. According to this view, beyond a limited list of examples like we have just gone through. It must be left up to you to decide what you should disclose. Do you agree with that? Do you agree that a lot of the decisions about what to disclose by necessity need to be left up to the individual? What risks does that create? The basic issues here are, how can you make the disclosable interest clear to all without making an overwhelmingly long list? And secondly, where does reasonable disclosure cross the line into unreasonable intrusions into your personal privacy and that of your family, friends, or acquaintances? These are the issues you have to consider when dealing with conflict of interest and disclosure. As an example of the latter point about balance, consider that many conflict of interest rules include spouses within beneficial groups and require people to disclose their spouse's interests. If a benefit to a spouse would bring in conflict of interest issues, should spouses be required to disclose their interests? If they're not so required, what would stop someone from simply transferring any disclosable assets to a spouse? But if they are disclosed, what about the spouse's right to privacy? Would confidential disclosure work for spouses, where the information is passed along to someone who will only use it for the proper purposes? Where should we find the perfect balance between managing conflict of interest and unreasonable invasion of privacy? Now, not all interests are created equal. We've already raised the issue of thresholds when you talk about disclosing interests. Remember the International Agency on Research on Cancer table? That works well for financial interests. But what about personal interests? In an attempt to define significance in private interests, the International Bar Association created a ranking of conflicts to guide arbitrators. To an extent, it can also be used by us. The system divides interests into 4 groups. A red, non-waivable interest group, a second red group for waivable interests, and orange interests and green interests. These lists are not exhaustive, they're only guiding examples, and you should feel free to add some of your own or modify them to suit your circumstances. But I'd like to go through the lists in more detail. The most serious list is the red list. Here you are assumed to have a conflict of interest. Now, there are actually 2 red lists. The non-waivable red list includes situations that could be perceived as being your own judge. In such cases, you cannot accept the assignment, even if all parties ask you to. The second red list is the waivable red list. This covers situations that are serious, but not as significant as the non-waivable list. In these cases, conflicts can be accepted if all parties, being aware of the conflict of interest, expressly state their willingness to have you complete the assignment. Moving down the serious list, we have the orange list. Here we have situations that may give rise to doubts as to your impartiality or independence. In these cases, parties are deemed to have accepted you if After you tell them about your interests, they make no objection. That is to say that a lack of an express objection creates an assumption of agreement. Lastly, we have the green list. These are interests that are so insignificant that there is no reason to disclose them. That is to say that your personal privacy outweighs any conflict of interest issues. Let's try some examples. Where would you put each of these? One of the red lists, orange, or green? Say a close family member of yours has a significant interest in the outcome of the issue you're deciding. Where would that go? Or you recently served as an advisor against one of the parties, but in an unrelated matter. Or you have a close personal friendship with an advisor of a party. Or you have publicly advocated a position on the issue. Take a few moments to consider where you would put those in the red, orange, green list categories. Now let's get down to what the lists actually contain. Taking the non-waivable red list, we have issues largely where you stand to make money. On that list, we find such things as you have a stake in which way the issue is decided, or are employed by someone with such a stake. Or you are a manager or a director of one of the parties that has a direct economic interest. Or you have a significant financial or personal interest in one of the parties. Or you currently advise a party and you or your employer derives significant income from the advice. I should mention that the participant guide has the full lists for all 4 groups. The waivable red list looks more at business relationships. Includes such things as you have given advice on the issue to one of the parties, or you represent or advise one of the parties, but you don't get a lot of income from such advice. Or your employer currently has a significant commercial relationship with one of the parties. Or you have a close family relationship with one of the parties. Moving down into the orange list, where the less serious list still deals with relationships, but now they're getting more remote. Here we find that you served as advisor for or against one of the parties, but in an unrelated matter. Or you have a close personal friendship with a manager or a director of a party. Now, how close is close? Again, one of the fun issues to discuss. Or you hold significant shares in one of the parties, with those shares being publicly traded. Or you have publicly stated a position on the issue that you're looking to decide. So these being on the orange list, once you disclose the interest, if no one actually objects, then they are assumed to agree. And lastly, we have the green list. Gets into more distant relationships that, at least in this scheme, are not even worth disclosing. On this list, you can say you have previously expressed an opinion concerning something relevant to the issue, but not focused on the issue. So you may have, if we take, for example, immigration. You expressed an opinion that immigration should be spread around the country very equally. But the actual issue to discuss is the number of immigrants which should be allowed from each country. You expressed an opinion concerning something relevant to the issue, but not on the specific issue. Or you could say you and one of the parties belong to the same professional association, or social or charitable organization, or a link through a social media network. So the fact that you belong to the same church as someone else who is on one of the parties is not worth disclosing. Or you hold a small number of shares in one of the parties which is publicly traded. Again, your financial matters, given that it's a small number of shares, are not relevant. Or, when advising on another matter, you learned of facts relevant to the current issue. So what you learn by mistake, by happenstance, in this scheme, is not a disclosable interest. So the red, orange, green lists are just examples of how one group tried to help its members with the concept of disclosure. The lists are neither exhaustive nor unchangeable. You should feel free to add, delete, or modify the entries as you will. As we've seen, there are some basic issues in disclosure, including what to disclose, when to disclose it, what is a significant interest, how to balance full disclosure with privacy, how to avoid the impression that any interest is acceptable once it has been disclosed. You need to consider all of these issues as you tackle conflict of interest policies. On the issue of when to disclose interests, some organizations, especially governments, have used advanced disclosure or advanced waivers. This is when you disclose all of your interests, usually to a conflict of interest commissioner, an ethics commissioner, or some similar person, when you first take up a job or a position. In theory, then, when an issue arises, the parties can go to your list of interests and start deciding whether you have a conflict. While possibly efficient, such lists are hard to keep current. Think of how many times you forgot to update your information when a credit card expired. Also, the other parties must remember to check the list, something they may not do if they do not think you have any reason to have a conflict. Advanced waivers have also been accused of breeding complacency. As the U.S. Congress has noted, the introduction of the Register of Members' Interests, designed to further the wholly admirable concept of disclosure of interests, has tended to create a false impression that any interest is acceptable once it has been registered, and so to add to the confusion which has developed. What do you think? Could advanced waivers add to the confusion? I would like to conclude our discussion of disclosure with a case study. Recall from the last module that Paul Martin, when he was Finance Minister of Canada, still had a significant interest in Canada Steamship Lines. Assuming that his interests were placed in a blind trust, what, if anything, should Mr. Martin be required to disclose? We stated in the last module that Mr. Martin did have a conflict of interest, so that fact should be disclosed. But in what detail? Should he just disclose he has a financial interest with no details? Should he disclose the precise value of his holdings? Or perhaps just say it is over some threshold? Should he disclose the interests are in a blind trust? If so, should he disclose the name of the trustee? And what about his wife? Should Mr. Martin disclose whether or not his wife has an interest? And if so, the value of the interest and whether they are in a trust? And lastly, what about the children who may have an interest? And especially disclosing the interests of underage children. This is just a short example of some of the weeds we must wade through when we deal with disclosure. We've now defined conflict of interest, discussed how to recognize them, discussed remedies, discussed disclosure. We'll now bring all these together in conflict of interest policies. I invite you now to move on to Module 8, where we will discuss writing conflict of interest policies.